Hello, this is Joe Cordell for another episode of Cash Counsel. So I want to pick up from where we were last week. We were talking about small businesses and how you might affect the valuation of the business, what role the business might have in the division of assets, how it might impact maintenance. I think we even maybe discussed the issue of child support, at least indirectly, to the extent that you calculate income and assign income. So all these things are relevant to people who are on the threshold of a divorce. And I want to talk about some additional things that could be relevant. One issue I want to cover is whether or not you want to consider a conveyance. Now, the conveyance of a business can be driven by a number of considerations. Remember last week we talked about the fact that if you're wanting to be a primary custodial parent and you think that your work schedule historically has been an impediment to that, may be viewed dimly from the perspective of the court, then you may want to position yourself to have more time, more flexibility. Now, usually owning a small business is not inconsistent with that. Usually if your objective is to have primary custody and you own a small business, often it is very practical to make the sort of accommodations you need to make to prove to a court that, yes, I do have time to own this business and to be a primary custodial parent. But of course that's not always true. Some businesses by their nature require travel. Maybe they require a whole lot of your individual time in the business. Remember that there are things you can do, and don't rule out the possibility of if you're wearing 3 hats and filling 3 job descriptions, maybe you want to bring somebody in to fill those other job descriptions. Those accomplish a couple of things. They position you better, which is the primary topic of this section, is positioning yourself better as it relates to primary custody, but it does another thing. It increases the expenses of the business, decreases the value of the business overall, depending on how those are built into the calculations. But to the extent that you increase expenses, you reduce net income, and if you're doing a valuation based on present values of cash flows we talked about last week, then you know that that's going to reduce the value of the business, which is helpful if you're looking at divorce, typically. Now, but let's talk about, though, other things, other reasons you might have for considering selling the business. Certainly there are other changes that are going on at the time of a divorce. It might be that you simply don't want to continue doing what you're doing. It might be that there's another buyer that is someone who you would continue to influence and who you would continue to have a relationship with, and that you don't mind their owning the business versus you're continuing to own it yourself. Now, if you're talking about conveying a business while the marriage is intact, then you're going to need your wife's authorization to do that. So it has to be a joint decision, and you need to jointly cooperate. Now, whenever we talk about making any of these moves, keep in mind that if you already have a petition for divorce pending, then that severely restricts the range of options. So don't assume that if your case is pending right now that you can readily go down a number of these roads we discussed without the participation of the opposing party. So you have to think about how you're going to pitch these various approaches. But let me assume that some of you are further back than that. Some of you have not come to the point where something's been filed with the court, and you may not even have directly decided, either of you, that you're getting a divorce. Where you're at that early of a stage, then it does create a lot of opportunity that doesn't exist longer. One way to think of this over time is think of a sort of narrowing funnel effect, and that's to a great extent how the circumstances are going into a divorce. You know, whenever you're approaching a divorce but nothing formally has been commenced, then you're at the wider mouth of this funnel. And then as you move along and conversations are had about divorce, maybe somebody sees a lawyer, maybe you and your wife have negotiated certain things. Finally, there's a point where something's filed. Well, when something's filed is kind of when you get to that narrow part of the funnel where it's the same width all the way through the balance. Well, that's kind of represents that stage from when something has been filed until the conclusion of the divorce. After that, it has to be fully the result of a negotiated deal for you to make those sorts of changes. The court is too involved, and virtually every jurisdiction has a number of rules restricting the unilateral decisions that either party can make after the filing of the case. The whole idea is to create a sort of status quo. It kind of makes sense, doesn't it, that you don't want, while the case is pending, either party to willy-nilly empty bank accounts and dissipate assets and make decisions about moving with children to other jurisdictions. You can imagine the sort of havoc that can be, and in fact has been, wrought over time in divorces. So these rules are pretty much standard throughout all the 50 states. But let's go back and let's assume some of you are at a sufficiently early stage to where your range of options are at the widest part of this funnel. What might you do? You might consider selling a business. You remember, if you're going to sell it to someone who's a related party, quote unquote, that can have implications from the IRS perspective as well as from the perspective of a divorce court. There's a certain jaded sort of distrust that the IRS and divorce judges tend to have whenever you're doing those related transactions. So it needs to be arm's length. You need to have documentation indicating that this is a transaction for fair market value. And you want your wife, generally speaking, you want your wife to participate in that decision. You want her to sign off, not necessarily formally, but definitely informally. You want the evidence to be there that this is something that was the product of a joint agreement. And there are a number of ways in which you may cast that or you may achieve that. That's up to you, knowing your wife and her priorities. But some of you, I know, have considered getting out of your businesses, and you're thinking, gee, should I do this now or should I do it down the road? I would argue that if you're on the threshold of a divorce, or you think a divorce might be coming down the road, and you want out of your business, that the time to do it is in advance generally. But here are some factors to keep in mind that will influence that decision. Remember, the court is going to hold you to some extent to your income situation as you come into the divorce court. So if you have a history of having earned $100,000 a year with your small business, and you're thinking about making a move that could result in initially $20,000, $30,000, $40,000 a year, then that's something you need to think about how you're going to explain to a judge. Not that it can't be accomplished, but you can't simply go into court and present that new set of circumstances and expect the court to accept that number for calculations of maintenance, child support, etc., without some explanation for you as to why this was done. If a court believes that you have deliberately disabled yourself in terms of your income or your assets as it pertains to future support, then the court can ignore this disability. The court can do the calculation as if you didn't have it. It's called an imputation of income, where the court imputes to you what they think you rightfully can or should earn. So you need to consider that if you're going to make a move that's going to reduce your income, do it early, number one. Do it substantially in advance of having something filed with the court, unless, of course, your wife is agreeing. If she consents, it's no problem. In other words, it was a joint decision. But to the extent, though, that you're at a stage where you're going to do this, it's a unilateral decision, you feel strongly about it, it's going to reduce your income, it's better to do it at a point sufficiently far back to where the court is not going to think your motives are in any way suspect. And it's really a matter about motivation. So if it's sufficiently in advance of anything being filed with the court, preferably, ideally, before there's even evidence of the contemplation of a divorce by you in particular, then it means that sure, you made this decision during the course of a marriage. Why should a court force you to go back and do something that wasn't related to the fact of divorce? It was a lifestyle decision. You're allowed to do those things. It's very unusual for a judge to say, when your income is plunged by 50% or more, it's very unusual for a judge to say that they're going to impute to you that higher amount when it was a decision made some time back, preferably, and clearly without reference or anticipation of the divorce. Now, when you think about selling the business, though, you have to think about what is going to be the result. What would be your alternative course of income? Now, it might be that you actually would sell the business, which could be losing money, so you're not going to get much on the sale of the business, and then you're going to obtain employment by which your income will go substantially up. So that's kind of the opposite scenario, where you're contemplating a course of action that's going to result in your income going up and the business going out. Now, I'm assuming if that's the facts, then we don't have a dissipation issue with respect to the business, meaning an argument by opposing counsel or a suspicion on the part of the court that you did this to get a valuable asset out of the business, whether or not it's to a related party. Because presumably, if it's losing money, you're not getting much value. Remember, when we talked about valuation of businesses, we mentioned that there are circumstances in which the best value is the breakup value. In other words, the sum of the component parts. Well, that's what I would suspect would be happening with a very low-earning business. But it may not be the case. It might be that you have relatively low earnings, but nonetheless significant earnings, and as a result sufficient to value the business as an ongoing concern, and yet you've made this decision that, gee, if I quit doing this, I can make substantially more. This is not something you'd obviously do in advance of the divorce to position yourself for a divorce, but at the same time, it's something you want to think about. It does increase your income. It does get this asset out of the marriage, but is it the best thing?